Welcome to Case by Case. This is a podcast brought to you by Callum Chain and Luke Zadkovich from ZFZ. How are you, Callum?
I'm very good. I'm pleased to be back on the podcast, Luke.
Yeah, so am I. It's been a little while. We've been super busy with lots of different things, but it's good to get back on the pod.
It has been a while. I think time's got away from us a little bit towards the end of the year, and then time's kept getting away from us for the first couple of months of the year. But now we're back.
We are back. We've got to get back into our stride. It's like one of those things where I think, once you're back on the horse and you're galloping along, it's fine. But, trying to squeeze it into the busy schedule if you don't have the habit is tricky.
It's exactly that. Once you're in the rhythm of doing it, then things get faster. The setup gets faster. You can read through the case with an eye to what's going to be an interesting talking point slightly faster. But the first time, I found it quite tricky, this one, to find all the right things to say and to get all my notes down. So fingers crossed this one goes okay. We're in good hands in a judicial sense for this first one back, because we've got Lord Justice Males. So we are the fan club is reunited for a Lord Justice Males very, very salty, shippy dispute.
Yeah, it felt like familiar territory going back to a Lord Justice Males decision. For those long-time listeners of the podcast, you'll be aware that we have cherished reading many of Lord Justice Males' judgments over the years for a number of reasons. One, they're almost very hard to argue against. Number one, they're so well written, if I'm allowed to say that. But it just, I don't know, it just has a way of getting to the nub of these issues in a really enjoyable way from a reader's perspective.
Exactly. They read in a nice kind of flowing narrative way. They're often actually much, in some ways better than the legal textbooks to come back to on your points of law, because they set out the point in such a clean, erudite way. Those are always a pleasure to read and always a pleasure to discuss whenever we get a nice Court of Appeal Lord Justice Males decision coming down.
Yeah, and we're dealing with a key point here. We're, as you say, back in maritime territory. We're looking at a legal dispute that has arisen out of the MV Ever Given issue that, cast your mind back to March 2021 when the Ever Given got stuck in the Suez Canal and was kind of in the headlines on global news all over the world, and it was the hot topic at that time. And we're looking here at a dispute between the owners of that vessel and a salvage company, and whether an agreement, a legally binding agreement, was entered into between the owners and the salvage as to how much they would be paid. Or if there was not a legally binding agreement, then the salvage company would be able to fall back on the International Convention on Salvage and obtain a salvage award, which is, as we know, a no cure, no fee type scenario where it's kind of high risk but high reward. So what do we have here? Do we have the contract where it's all agreed, or do we have no contract but a high reward in the event of success?
Interestingly, because it doesn't feel that long ago, as of the time of recording this podcast, we are on the eve of 3 years to the day since the Ever Given got stuck in the Suez.
Wow, that long ago. A lot has happened in our world since then.
It has. Imagine if that was the biggest disruption to global shipping in the last 3 years.
Yeah, exactly.
A few competing factors have been slightly more disruptive than this ship that made headline news all over the world.
Quite. Exactly. So where to start here? Is it worth a little recap on the facts, or are we kind of, do we know enough about the facts just to kind of jump into the correspondence between the parties? Because this is all about whether a contract was formed, and that's going to turn, as it does, on the written exchanges at the time. It can be informed by oral statements that were made between the parties as well. But it's really an exercise in looking at the exchanges between the parties objectively, so not what they objectively they agreed or did not agree, and kind of examining those messages back and forth. So where to start, Callum?
If we start with the facts, then we'll do the whole thing, because it's a very fact-sensitive case. Maybe we do the reverse of what we normally do and start with the legal principles in play and then apply that to the facts.
Yeah, I think that's right. I think it's an important point to emphasize, actually, from the outset, that often these types of cases where you're looking at whether a legally binding contract was formed or not, they are very fact sensitive. So the answer to the question in this case may be different to the answer in a closely analogous case, but different, right? And you really do need to look at the specific facts of the case to determine whether a contract has been formed or not, particularly where the parties have not used some of the usual terms, such as subject to contract or fixed on subjects, subject details, things like that, which is very clear when a party is negotiating but reserving their position pending a formal signed contract. And the parties didn't use that here. And so that's not determinative one way or the other. It just almost means there needs to be a closer examination of what they said to each other.
And I think also in the context of salvage, this is particularly interesting because you would often, if you have a situation where there are two parties and each says, one argues that there was a contract, the other argues that there was not a contract, then the performance, the contract can sometimes be implied by performance. So if party A says, no, there was never a contract for me to sell you that parcel of oil, and party B says, yes, there was a contract. If in fact the parcel of oil was sold, then the starting point will be, well, there seemed to have been a contract. There seems to have been something agreed here. In the salvage context, that doesn't quite work because it's entirely possible for a salvor, in this case, a company called Smith, to perform the services without any contract because of the way that that salvage remuneration can be obtained for a successful outcome. Essentially, a salvor can speculate that their performance will entitle them to remuneration because they will succeed in the salvage. So there's no kind of starting presumption that because there was performance, there must have been a contract. So this is an interesting look at whether a contract is performed because you can shut your eyes to that to the actuality of performance.
Yeah, that's true, and I think it's a really insightful point, Callum, if you don't mind me saying, in that it's not that performance is really going to be determinative here, and the salvage company may actually start to perform before they've got an agreement in place. They may bring in tugs that could assist in the salvage operation, as you say, somewhat safe in the knowledge that if they go ahead and perform the salvage services without a contract in place, that they are able to fall back on international conventions or the common law and bring a salvage claim in the event they're successful. That said, there is still some commercial incentive on salvors to agree on rates, because from a salvage company, there is speculation as to whether they're going to be successful or not. And that can depend on factors outside their control. It can depend on how stuck the vessel is, how hard it's going to be, whether the vessel ultimately is lost and not recovered. So to speculate does carry risk. And of course, that's reflected in the high risk, high reward kind of scenario if there's no contract. But there is an interest from a kind of, a prudent operation perspective for salvage companies to have agreements in place before they go ahead. It's not completely one way or the other, if you know what I mean. There is still some incentive for salvors to agree on contracts. And what's interesting in this case, I'm sure we're going to get into it, is that owners really relied on what they call 3 ultimatums that were, they say, made by the salvors. Unless we get some form of agreement here, we're going to pull out, and we're not going to commit to the salvage operation. Now, there's some stuff to unpack there. But you can see, at least from the tenor of those communications, that one way of characterizing them is that the salvors wanted to get a deal before speculating.
Yeah, you can see from the correspondence that salvors did want to get a deal before speculating. And the facts of the case kind of play out in salvors' favor a little bit. The heat comes off because of circumstance, at least from the salvors' side. It goes from being fairly speculative to actually less speculative, because these particular salvors have the kind of heavy machinery that it becomes apparent that will be necessary to free up the ship. But maybe perhaps before we go into that, there isn't a lot of law on this, as you say. It's very fact-based. The real question is whether there is an intention to be bound on certain terms that are exchanged. Essentially, what's happened here is there's an initial attempt to set out some terms, kind of an offer on terms made by the salvor. The salvor says, these are the terms on which we're happy to perform. And those terms include a reference to a full contractual agreement, setting out all the different terms that you might expect to see in one of these contracts. There's then a response further down the line, and the response is from the owners, and the response from the owners is purely focused on remuneration. So what are the salvors going to be paid? The salvors and the owners seem to agree that remuneration part of the contract, but not all the other parts of the contractual matrix that the salvors want to be agreed. And the salvors' argument is, we didn't agree a contract on the terms of the remuneration. We simply resolved the remuneration issue, and the rest of the contract was then left to be finalized. But until it was finalized, we didn't have an agreement on anything, because we only intended to be bound on remuneration when we're bound on everything. So it's a situation where you're trying to say that there's a part agreement, if you like, which is perfectly possible under English law. Parties can agree some terms and then leave other terms to be agreed later. That's not a bar to a contract being formed. But there are certain principles that need to be applied in working out whether you have a situation where there is a part agreement with more of an agreement to go, or alternatively whether there's no agreement until the whole thing's agreed. The easy way is the one you said, Luke. You're right. If you have subject to contract, then you know that nothing you say is agreed until you sign until you sign the contract. But here we didn't have any of that language, so it left it open for this case to be tried.
Yeah, exactly. And I think this is a key paragraph of principle, just reiterating what you've just said there, Callum, at paragraph 19. In summary, it is well established that the whole course of the parties' negotiations must be considered, that it is possible for parties to conclude a binding contract even though it is understood or agreed that a formal document will follow, which may include terms which have not yet been agreed. That whether this is what the parties intend to do must be determined by an objective appraisal of their words and conduct, and that the burden lies on the party asserting that such a contract has been concluded to establish that it has. So in other words, it is most certainly possible for parties to agree on a contract even though other terms are yet to be agreed, discussed, and kicked off into touch for down the track. It is still possible to have that agreement in place, and it will turn on an objective assessment of what the parties said to each other in writing or orally, and their conduct. And finally, importantly here, as is emphasised when we get to the conclusion in this matter, that it's on the party that is asserting that a contract is in place to prove that it has. And so those are kind of the guiding principles here. And that's why it's very fact-specific. It depends a lot on what the actual language is and how the parties reacted. So we have the kind of two sides to this. One is owners saying that there was an agreement as to the remuneration that salvors would be paid. And yes, there were some other terms to be ironed out, as it was put, but that there was a deal. There was a deal. Both parties intended through their conduct and their words that there was an agreement on remuneration, and they were, if you like, bound at that stage to that agreement on remuneration. The flip side is, which is the salvors' position, was that agreeing to remuneration, if you like, was just one of many of the areas to agree before agreeing on the overall contract. And Salvors had proposed many terms, including the standard to which they had to perform. There was a full document of terms that had been put forward by the Salvors to the owners, along with, of course, the remuneration section. And just because they had reached an agreement as to what the remuneration would be, doesn't mean that yet the full contract had actually been agreed. And their conduct was, they say, was more consistent with requiring everything to be agreed and the full contract to be finalised before they were, if you like, fixed at all on this contract. So those are the two camps here, and where the arguments lie.
And I thought this ultimatum point was a really interesting one. This was the point raised by the owners. So to strip it right back, the owners are now saying there was a contract agreed on remuneration. The salvors are saying there was no contract agreed on remuneration. We were doing it on this open basis. And the reason that salvors are saying there was never a contract is that because the vessel was ultimately refloated, the salvors would be entitled to a more significant sum. If there is no contract, then they were bound by the contract. So salvors are saying there is no contract, and the owner's argument on appeal was really that you could, I suppose it's a commercial argument to say you could see the point at which the contract was agreed because the temperature drops in these very intense discussions, and you have these, the salvors are taking steps to try. Before anything's agreed, the salvors are taking steps to try and make sure that that they can assist in the recovery of the vessel. While they're taking those initial steps, salvors are very exercised about getting a contract in place, and they're sending messages to owners saying we need to have a contract in place. And there are these three distinct ultimatums that the owners look to, where they say, look, it's really clear here that up until the point a contract is created, the salvors are pushing and pushing and pushing to say we must have a contract before we perform. And then after the remuneration is agreed, owners say charterers completely go off the boil. Sorry, not charterers, salvors completely go off the boil. And the heat is taken out of these negotiations. To all the world, that must mean that once the salvors have what they want, i.e. a firm contract that they can rely on in respect of remuneration, they are less incentivized to continue the discussions. And the owners try and rely on those ultimatums to make the point that email exchange, where the remuneration part of the discussion is tied up, is in fact a binding contract. And I had a reasonable amount of sympathy with that argument, Luke. I don't know how you read it, but I think we've probably all seen these commercial discussions where it's a very tense back and forth, and then there's a point where commercially, at least, the deal is kind of thought to be agreed, and the lawyers then would come in and do the bits that mean that the deal is really agreed.
I think it's one of those classic cases where if you paused time shortly after that exchange and asked the commercial parties what's the position right now, you may actually get a different answer than what this decision ultimately went with. And let's note that this is a Court of Appeal decision, and the judge at first instance also did find that there was not a contract. And I'm giving the game away here, but ultimately Lord Justice Males and Lord Justice Popplewell and Lady Justice King agree, and so it's a unanimous decision to dismiss the appeal. So a number of judges at different levels have found that there wasn't a contract here, but I do wonder if you paused that time and asked some of the commercial folk over there at Smith at the Salvors what is the position, what you would find. Now, the court here, the Court of Appeal court, it's it found that if you look at the ultimatums, that the ultimatums were still premised on what could be at least viewed as premised on agreement as to all the terms, and that they weren't simply limited they weren't simply limited to getting an agreement on the remuneration only. And almost from the outset in the negotiations, the salvors had adopted the position that they wanted agreement on everything, subject to negotiation, but they wanted all terms to be agreed. And there was nothing that they did other than perhaps the temperature dropping after this preliminary deal was done. But there was nothing that was said that really changed from that position. It would have required a change in tack or some message that said, okay, if we get agreement on remuneration, that's fine for us for now, and everything else can be sorted out down the track. The ultimatums that were given could be read, and Lord Justice Males goes through each of them, as still requiring agreement on all of the terms. And I think it's worth keeping in mind that what was being contemplated at this time was a very rapid finalization of those terms. So while they received the deal on the remuneration, let's say, or that was kind of locked in, it was contemplated that the contract and everything else would be sorted out very quickly thereafter. And let's also remember the circumstances in which we're dealing with. This is a huge, huge problem, company-defining problem for these owners, biggest issue in the world for years, closing down one of the major arteries of global shipping. And there's a lot of pressure to get this done. It wasn't a case of, okay, let's just agree on price and we'll get the terms all wrapped up over the next few weeks. It was very much contemplated that the rest of it would be done in short order, as I read it, and I think that kind of adds to this point from Salva's perspective.
Yeah, and I think if we take that at face value, then I didn't love the argument that the ultimatums could be taken as being an ultimatum for the entire contract, because the way the facts played out, the ultimatums were given, the remuneration part of the agreement was agreed, and then the threatening part of the ultimatum wasn't carried out. So the classic ultimatum is, if you don't do X, I will do Y. In this case, if the salvors never did Y, the thing that they were going to do if the ultimatum wasn't successful was pull out and not provide the salvage services. But they did provide the salvage services, and they did provide the salvage services after without any further ultimatum after the remuneration was agreed. So my initial take I didn't initially love that response to the ultimatum argument, because it suggested that the ultimatum was always a false one, in effect, because if they gave the ultimatum, didn't get what they wanted, and then continued to provide the services anyway, that's not they're obviously not following through on the ultimatum. And I think what Lord Justice Males says on that point is that although they had those ultimatums, and although the request in the ultimatum was not fulfilled, the circumstances had changed by the point at which they would have withdrawn from providing the services, because a previous reflotation attempt had failed. And the nature of that reflotation attempt failing meant that the salvors were in a very strong position to succeed. So the likelihood of them not recovering sums on the kind of open basis, if the LOF basis, if they were to succeed in refloating the vessel, was diminishing by the day. And therefore, they wouldn't necessarily have wanted to put this ultimatum on the owners, because they actually would have been potentially in a worse position. So I think it's interesting, going back to what would they have said if you had been able to speak to the commercial people at the salvors on the day all these agreements were being made, I suspect it's one of two things. One, they would have said, yes, that's fine. We've got the remuneration agreement. Let's carry on. Or two, it would have been, we don't have any contract, but owners aren't really picking us up on it. So we're just going to get remunerated on the open basis. If we manage to refloat this ship, and let's just stay quiet and hope that we get that.
Yeah, there's probably a point in there as to when exactly you do pause time on that, and when the circumstances changed, and at what point is that their position? I think that's right, and that is what ultimately the court here hung the hat on. It's an interesting one. I can see why it got to Court of Appeal, and there's obviously a lot on the line. I agree with the decision and the reasons that are given there, but I also did have quite some sympathy for the owner's argument here on the ultimatums. The salvors were very much pushing for that deal, and once they got that deal, the temperature came out of the communications, and they seemingly cracked on with things
very, very quickly. Everyone just went about business as normal. What I found interesting in that context, the strength of the conclusion from the Court of Appeal was pretty firm. I think both of us on this podcast are reading what happened with some sympathy for the owners, and the sense that actually it does track that there is some kind of agreement where the salvors feel like they are safe to provide the services. They have security of the remuneration that they've been chasing, and the sting goes out to the discussions. So we have some sympathy, I think, with the owner's position. I certainly do. The Court of Appeal did not. They were pretty firm in their decision. Burdens on the owners to demonstrate that the parties' exchanges evince unequivocally an intention to be bound. In my judgment, and in agreement with the judge, they fall considerably short of doing so, which is really a fairly strong dismissal of the appeal.
Yeah, I read that. I saw that too. I reflected upon it. And of course, these decisions are not based on sympathies and what have you. They're based on, as we've explained, an objective analysis of what the parties have said to each other and their conduct. That said, almost the way that it's written, there is this element of prevarication by the owners, and this was such an urgent issue. There was so many things going on here to solve. It was causing such a major problem. It's unclear. You don't get the full picture here, so you don't really know what was going on. And I'm sure it was a state of chaos, really, trying to deal with this type of issue. But there was some back and forth where owners had a number of opportunities to just lock things up. They sent a message confirming the position and then retracted it. Things took overnight to get back to them. And then eventually they respond and say, well, on the full contract, this is going to have to wait for senior management decision on Monday. And I don't know, it just read a little bit like, why isn't this getting agreed quickly? If you wanted a deal, you wanted to lock up this deal with the salvors, agree it within the day, get it done within hours, get the salvors out there and into action. Now, what we don't know is whether owners were talking with other salvors. Maybe there were negotiations with other salvors going on out there. That doesn't come into this judgment at all. There could be all sorts of very valid reasons for how the owners conducted the negotiations in the way that they did. But I think what I'm trying to say is the fact that owners didn't just come out and very clearly say, yes, X, Y, Z is agreed. These other terms are not agreed. Come back to us on whether we can lock this point in or that point in. There was some of that, but it was a little bit like, why is this not locked in? Why are salvors having to make 3 ultimatums to try and lock in a deal that should have already been locked in? I don't know. Maybe I'm overreaching in that kind of speculation, but there's a little bit there. I don't know what you make of that, Callum.
Yeah, I think it's a very good point. Not one I'd really considered. There was significant opportunity for this contract to be agreed. In the context of it obviously being total chaos and it obviously being a very stressful, difficult time for the owners, but they did have the opportunity to confirm these points. They did envisage that these points would not take a long time to deal with, and there was a time where they were in a position to negotiate these terms. And I think there's probably a practice point in there, which it's just to get these things buttoned up when you have the momentum and you have the opportunity to make sure that everything, the I's are dotted and the T's crossed legally, particularly in the salvage context, but really in all contexts. It's the same with charter negotiations where things are on subjects. You don't want to let things stay on subjects for too long. You want to make sure that when the parties are, we have that meeting of the minds, the last little bits get taken care of, and the deal goes ahead as quickly as possible. Because when you lose them, when circumstances change, then you give the opportunity to one party to take advantage of the different facts. And I'm not suggesting the salvors took advantage of the changing circumstances here. But even if they did, then it seems like they were entitled to, because they weren't bound or committed to this contract, and they were the ones, as you say, who were pushing to get everything tied up together. And it did seem to be owners who were slightly slow on making sure that everything was tied off in one package.
Yeah, and look, we're making these comments without any intended criticism, because the salvors, their business is dealing with these types of casualties. Owners hope never to have to deal with this, and if they do, it's a one-off, right? So the lawyers involved and underwriters and insurers and others, that it's not their first rodeo on casualties, but it's not intended in a critical way. I suppose the point I'm making is that from a court's perspective, what is the takeaway? What, as you say, a practice point? What is the takeaway from this? If part of a court's role is to ensure that justice is done and setting down precedent for future scenarios. If you're reading this and you're in the world of dealing with casualty disputes and locking up salvage contracts, there's some pretty clear takeaways from this decision. And I think the ultimate decision is consistent with what the court wants to be pronouncing about how parties should conduct themselves in these types of scenarios. That's kind of what I'm saying. And I'm not for a moment suggesting this is a policy-based decision. The upshot of the outcome here kind of heads in that direction.
Yeah, I totally agree. And it's not the sort of situation where there could be any criticism. We've all been in those situations where things are moving at 1,000 miles an hour, and it is you. No matter how much you try, you cannot put yourself in the position of the Court of Appeal in 3 years' time, dissecting all the correspondence that's gone between you. You just don't have the time in the day to think in that granularity. So these things happen. They get played out, and the court then looks through them. And I do think that it's something to try and bear in mind. Is how is a court going to look at this when I suppose the one point I'd say is that it always seems less urgent when you're talking about urgency in the court a few years after the urgent thing happened. It's hard to explain to the court quite how urgently things were, or quite how fast things were moving, or quite how many plates were spinning at that point in time. Because owners weren't just looking at salvors. Presumably, they would have. This was a big liner ship. They would have had customers jumping up and down. They would have been coordinating a crisis response at the time, and part of that would have been the salvage contract. But they wouldn't be envisaging that 3 years down the line they'd be sat in the Court of Appeal trying to explain that once this remuneration part of the agreement had been concluded, they didn't feel a need to go and conclude the rest of the contract. They would have just probably thought, the remuneration part's done. Let's go. Let's let the salvors put the ship. So it's absolutely not these situations never really criticism of anybody. It's just that the court will always look at it with that kind of clinical forensic, if you like, approach to what actually happened.
Yeah, and it's interesting because one part of the facts that I don't think we touched on is that on the Monday when senior management of the owners had input into the full terms and come back with a number of changes or proposed changes to those, that was either on the day or right around when the vessel was successfully floated. So we're talking about a relatively short space of time, but enough time for the salvors to have done their job, incurred expense and brought in resource, and obviously ultimately done a great job and was successful here. But had, what would have been the position, Callum, if it took another week to get that deal done? It would have been very interesting, I think, had this played out and those changes had been proposed on Monday, whether ultimately there was an agreement come Tuesday and the successful refloating happened a week later, let's just say. I think that would have been a very interesting proposition. I'd be willing to put a couple of bob on it that there may have been a signed contract that found its way in place had that played out.
Yeah, I think you're probably right.
Anyway, interesting. I think this was a great one to get back into the seat on, Callum. Good to chat with you. I've always enjoyed these, contract formation cases, and we have many of them on the go at any one time. But they are very fact specific, and each of them turn on their own facts. It's not kind of the type of decision that you can just like say, this is the answer here, so it's the answer there. There's some guiding principles as we have talked about, but actually you've got to look at each individual case on its own merits.
Absolutely. Well, look, I enjoyed it. It's great to be back on the horse. Looking forward to the next run of these podcasts.
Very good. All right. Thank you, everyone, for listening. We hope you've enjoyed today. If you have any questions on this or any of our other podcasts, do drop us a line. We're available to answer any questions you may have. We really enjoy getting the feedback. It surprises us. The listeners out there, some that we know dearly and very well, others that we don't know all that well, that drop us a line and say, what about this? What about that? So feel free, and we hope this generates some more discussion. Until next time, take care.
Cheers, everybody. Bye-bye.